Welcome back, Rich, and welcome to Risk Management Live. Today's topic is going to be the Supreme Court's gay marriage ruling, impact on pastors and churches. There were two recent rulings that happened last month, so we figured we better tackle them again. But before we get to that, I want to let you know that your questions and comments can be submitted to us by email at riskmanagement@agfinancial.org. You can actually go to the bottom page if you're watching this live right now and actually submit your questions. I get them right here as we're talking in the comment section, or you can do it by tweeting us. If you use Twitter, please direct it to @agfinancial or use the hashtag riskmanagementlive. Rich, the two court findings, which I was really kind of surprised that the Supreme Court came back so quickly, number one. And of course, there was a 5-4 split decision on both of these topics. But let's first talk about the Defense of Marriage Act and how the Supreme Court's ruling ruled on the Defense of Marriage Act.
Okay, Jerry, and let me begin by saying that the Supreme Court did issue these two rulings last month pertaining to same-sex marriage. And we're going to talk about both of these rulings and their impact on churches. But I'll just say this. I've received a lot of calls since these rulings, and there's a lot of concern, apprehension, anxiety even on the part of many church leaders regarding the impact of these rulings. There's a lot of people, Jerry, that feel that because of these rulings, pastors may be prosecuted or may be sued for civil damages for refusing to perform a same-sex marriage contrary to their religious beliefs, and churches may be subject to some liability if they don't permit these marriages to be performed on their premises. Those are the two pressure points. I think those are the two most common concerns that I hear, and I've had a lot of church leaders call me about these. So today, this was not our intended topic for today, but we decided to cover this to try to relieve some of the anxiety out there by explaining what these rulings said and what their implications in fact are. So let's begin by looking at the DOMA case. And of course, DOMA stands for the Defense of Marriage Act, which was a 1996 federal law that Congress enacted by overwhelming bipartisan majorities of about 85%, signed into law by President Clinton. And Section 3 of this statute define marriage for purposes of federal laws and regulations as a union between a man and woman. So for federal purposes, not state, but for federal, marriage only, whenever you see the term marriage in a federal statute, it only pertained to marriages between a man and woman. And you say, well, what's the significance of that? Well, it turns out, according to one count, there are 1,136 provisions in federal law that use the term marriage or spouse. And so it's very critical how this is defined. And so for DOMA to say that it only pertains to opposite sex or heterosexual marriage had a significant adverse impact on same-sex marriage. So the Supreme Court in the DOMA case basically said that provision defining marriage solely as a union between a man and woman was unconstitutional for two reasons. Number one, it invaded the province of state and local governments historically to make decisions regarding marriage and domestic relations in general. Here we have the federal Congress defining marriage, and that has historically been a state or local function in this country. And secondly, the court said that that this section of DOMA defining marriage between a union between a man and woman violated the Fifth Amendment, or not the Fifth Amendment, but Article 5 of the United States Constitution, which incorporates the concept of equal protection. It only refers to due process, but the Supreme Court has interpreted that phrase to embrace and to encompass equal protection of the laws. And so the idea is this. Here in one of the 13 states and the District of Columbia that have recognized same-sex marriages as being lawful, you have some people being recognized as married under federal law and some people that are not under DOMA. Because under DOMA, even if you're in one of the 13 states where same-sex marriages are permitted for state purposes, they're not permitted for federal purposes. And so you had this dichotomy. You have this two classes of people. You have approved marriages, disapproved marriages. And the court concluded that violates the equal protection concept embedded in the due process clause of Article 5 of the United States Constitution. Now, it's very important to point out here that the court had the opportunity but refused to take it to come up with a sweeping ruling that same-sex marriage is a constitutional right, period. They didn't do that. It was a very measured, it was a very limited ruling that said that same-sex marriage in the states where it's valid, where it's lawful, 13 states plus DC, in those states, DOMA is unconstitutional because it would create a two-tier marriage situation with some marriages being recognized under federal law, some marriages not. So obviously, we've got 37 states that by statute or constitutional amendment define marriage as a union between a man and woman solely, no same-sex marriage. So in those states, DOMA still applies. So as you can see, we have emerging this kind of disparate treatment based on where you live, and that's why a lot of commentators, legal commentators and analysts believe that the Supreme Court inevitably is going to have to weigh in again on this topic. I'm not so sure that that's going to happen because there have been members of the Supreme Court, including some of its most liberal members in recent months, who have intimated that maybe they got the abortion ruling wrong back in 1973, Roe v. Wade, by appropriating that decision for the country and taking it away from the electorate. So you have 6 out of 9 judges say abortion is a constitutional right. And that's why we have had 40 years of turmoil in this country. And that will continue forever because the electorate, the people, were deprived of the right to make this decision. In most European countries, the abortion decision was made through the electoral process, and they haven't had the chaos and the anarchy that we've had here over that ruling. And so the idea is maybe when it comes to same-sex marriage, another controversial issue, maybe we should leave this up to the states to decide. So we may be surprised at how the Supreme Court ultimately would rule on that case, but it certainly is possible and perhaps even foreseeable that the Supreme Court would recognize a robust constitutional right of same-sex marriages. And if that does in fact happen in the future, I think it's important to point out that those 37 state laws and constitutions that define marriage solely as a union between a man and woman, they're going to be swept away by that singular ruling, probably in a 5-4 decision of the United States Supreme Court. So we'll just have to wait and see. And so, Jerry, you might say, well, what's the relevance of this? What are all these federal law provisions that pertain to spouses and to marriage? Let me mention some. Number one would be Social Security benefits. Under the Social Security program, benefits are made available to surviving spouses and to spouses in general, even if the other spouse is still living. And so the word spouse is used in many places in the Social Security laws. Or how about this? The tax-free status of employer-paid medical insurance for employees and their spouses. So you see, well, that depends on where you live, whether a spouse is considered a lawful status or not. And how about cafeteria plan eligibility? Yes, it's available to spouses. Or flexible spending arrangements and health spending accounts, expenses of spouses are treated the same as expenses of employees, but not non-spouses. How about sales of principal residences? The rules are very different. The benefits are different if a couple is married versus not married. And what about estate taxes? There's an unlimited marital deduction for spouses that same-sex couples are not going to realize in 37 states. And then, of course, whether or not you're eligible to file a joint tax return will depend on your marital status. So those are just a few of the more common. And I think that in practical terms for many churches, you're going to see, I think, the tax status of medical insurance paid by the employer is going to probably be, realistically, that's going to be probably one of the biggest impacts of this court ruling in those 13 states where same-sex marriage is recognized. And if you're in a church that is not opposed to same-sex marriage, and you have an employee who maybe is involved in a same-sex marriage, then that church is going to have probably to review the payroll withholding, have the employee submit a new W-4 form, and treat certain fringe benefits that pertain to spouses differently than in the 37 states where that's not the case. So those are some of the more important provisions under federal law of those 1,136 that are now in play.
Just an easy question. With the Defense of Marriage Act and with these provisions, if you're located in a state that does not recognize same-sex marriage, the federal benefits such as estate taxes, Social Security benefits, will those federal benefits not be available to people in the states that are located in one of those 37 states?
That's exactly right, and that's the disparity.
Okay.
You're treated favorably in some states, disfavorably in others, based on the status of that marriage. So that's why that is fueling litigation efforts right now to get this issue before the Supreme Court. And there's very little doubt, if you read some of the opinions, that a number of those justices were ready to make that decision on the spot, but they restrained themselves, and so we'll just have to see.
Okay, we've got a church that is doctrinally opposed to same-sex marriage, and it's located in one of the 37 states that do not recognize same-sex marriage legally. A same-sex couple asks the pastor to marry them. The pastor refuses to do so based on his religious belief. Does the Supreme Court decision striking down the Defense of Marriage Act expose the pastor to legal liability for failing to perform this marriage ceremony?
No, it doesn't. Number one, the court did not even address that issue in the DOMA decision. But number two, it only invalidated DOMA in those 13 states where same-sex marriages are legal, not in these 37 states where it's not.
Okay, let's say we have a church that is not doctrinally opposed to same-sex marriage, and it's located in one of the 13 states or the District of Columbia, and that recognizes same-sex marriage as legally valid. A church employee informs the pastor that she is planning on marrying a person of the same gender. How would the church be affected?
Well, this shows the disparity once again, because you can perform that marriage in this state because it's recognized as legal, and DOMA will not apply since same-sex marriages are legal in this state. So the court's ruling that it's unconstitutional would apply in those 13 states such as this one. Again, the biggest effect, Jerry, is going to be, practically speaking, in these kinds of churches, is going to be health care benefits paid by the employer for staff.
Okay, we have a church that is not doctrinally opposed to same-sex marriage in one of the 37, they're located in one of the 37 states now that do not recognize same-sex marriage. One of the employees informs the pastor she is planning on marrying another person of the same gender. How would this be affected by the court's decision?
Well, DOMA applies because you're in one of the 37 states that do not recognize same-sex marriage, so DOMA still persists in those states. And here we see that disparity again, which is likely going to lead to the Supreme Court weighing in on this issue.
So it's real important to pay attention to what state you're located in, and does your state have a constitutional ban on this? Because actually I know that right now there's several states that they're trying to push for that ban to be lifted. And if that changes in that state, the answers to your questions basically will change also based on if they are recognized or not.
Yes, that's right. That's exactly right. There are efforts underway, and these will continue to expand that list of 13 states where same-sex marriage is considered lawful. And I would suggest that we probably will see 3 or 4 or 5 states pretty quickly added to that list. Okay, let's move on, Jerry, to the Proposition 8 ruling.
Yeah, let's. The second court ruling that that the Supreme Court dealt with Proposition 8 in the state of California. Let's. Why don't you go through the changes that happened with that?
Okay. Well, the origin of this ruling was back, really, I would say, in 2008, a decision by the California Supreme Court that suggested that same-sex couples had a constitutional right to marry. Well, that led to a backlash and an effort that same year in 2008 that became known as Proposition 8, which was a voter initiative to let the voters of California decide how they wanted to define marriage. And it was, should we define marriage as exclusively a relationship between a man and woman? That Proposition 8 was enacted by, I think it was 53% of the citizens of California. And that was immediately challenged in a federal district court in San Francisco as unconstitutional. And the court allowed the proponents of Proposition 8 to defend it, which they did vigorously. And the court ultimately decided that Proposition 8 violated both the due process and equal protection clauses of the 14th Amendment to the United States Constitution, which are limitations on state action, not federal. And so Proposition 8 was deemed to be unconstitutional and invalid. Now, the interesting thing about that case was it was based on federal constitutional law principles, which theoretically would apply to all states. So, and the other thing about this case that I think is important is that the court had some very broad religious liberty language that addresses directly the perception of so many that these rulings are somehow going to impact ministers, who they can or cannot marry. And so let me quote from the court's decision. Affording same-sex couples the opportunity to obtain the designation of marriage will not impinge upon the religious freedom of any religious organization, official, or any other person. No religion will be required to change its religious policies or practices with regard to same-sex couples, and no religious official will be required to solemnize a marriage in contravention of his or her religious beliefs. So that was a significant recognition by the court that despite its ruling, the ruling itself, recognizing the constitutional validity of same-sex marriage, had nothing to do and in no way impacted ministers' religious freedom in deciding who they're going to marry and who they're not going to marry. Well, the proponents of, let me just say this. The party that could have appealed this ruling, striking down Proposition 8, to the Ninth Circuit Federal Court of Appeals would have been the governor, Jerry Brown of California, and certain legislators. They refused to do so. And so here you have a law enacted by the people that the governor and the legislature would not defend. And so the Ninth Circuit U.S. Court of Appeals allowed the original proponents of Proposition 8 to appeal it, which they did. And then the Ninth Circuit went on to rule that the district court got it right, that Proposition 8 was unconstitutional. So the Proposition 8 proponents then appealed the Ninth Circuit's ruling to the United States Supreme Court. And here the Supreme Court had an opportunity, again, to make a sweeping ruling, recognizing everywhere a constitutional right by same-sex couples to marry. They didn't do that. Instead, I would say on a technicality, the United States Supreme Court dismissed the appeal on the technical grounds that the proponents of Proposition 8 did not have standing to prosecute the appeal. Standing is a very important concept in federal litigation, and it's a constitutional requirement. And what it means is the litigants must have, to any federal lawsuit, must have a direct interest in the outcome of the case. And just the fact that the proponents of Proposition 8 were citizens and desired this, they did not have a sufficient interest to qualify for standing under the very complex definition of standing that the courts have come up with over the years. Now, so the court said the proponents of Proposition 8 didn't have standing, and therefore the Ninth Circuit was in error to have heard the case because those proponents didn't have the authority to appeal it to the Ninth Circuit. So it vacated the Ninth Circuit ruling, which had the effect of reinstating the San Francisco District Court ruling that Proposition 8 was unconstitutional under the federal Constitution. Again, they avoided ruling on a constitutional right.
So, by this ruling, will ministers be required to perform same-sex marriages?
Well, that's one of the two big questions.
Yeah.
And our church is going to be required to perform them. So let's take a look at that ultimate question. This is where the confusion is. This is where the anxiety is, Jerry, today. Pastors are asking, can I be in trouble? Can I go to court? Or can I be sued? Can I be prosecuted if a same-sex couple comes to me and wants to get married and I say that would violate my religious beliefs? I cannot do that. Are they going to be in trouble? And that's what we want to address here in the final minutes. Number one, the Supreme Court's two recent rulings did not address that issue at all. So we're left to look at other authority. Now, I will say that in 37 states, the validity of state statutes and constitutions defining marriage as exclusively a union between a man and woman, those are still intact until the Supreme Court decides otherwise. So for now, that's not an issue in 37 states.
You're located in one of the 13 states, though.
That's going to be the issue.
Yeah.
Or if the Supreme Court recognizes a federal constitutional right for same-sex marriages, which is a possibility, as we've alluded to. So what about the fact that you're in a state where same-sex marriages are lawful? Well, let me address that. And there's a number of points, I think, to make here. The first one is this. There are prior rulings by the United States Supreme Court that would suggest that the concept of religious freedom embodied in the First Amendment to the Bill of Rights is broad enough to protect ministers in making decisions as to who they're going to marry and who they're not. Let me quote from one. This is a case back in the 1950s that's still frequently quoted, where the Supreme Court said, "It is a very different thing where a subject matter of dispute, strictly and purely ecclesiastical in character, a matter over which the civil courts exercise no jurisdiction, a matter which concerns theological controversy, church discipline, ecclesiastical government, or the conformity of members of the church to the standards of morals required of them, becomes the subject of its action." It may be said here that no jurisdiction has been conferred on the court to try the particular case before it, or that its judgment exceeds the powers conferred upon it. So this and many other cases I could quote by the United States Supreme Court, as well as lower federal courts, indicate there's a strong probability that the courts would recognize, even if they recognize same-sex marriage as legal, they're still going to recognize the authority under the First Amendment guarantee of religious freedom of ministers to decide who they're going to marry and who they're not going to marry. The Supreme Court, just last year, in the Hosanna Tabor case, unanimously, now remember, these two same-sex marriage cases were 5-4 decisions by the court. The Hosanna Tabor case last year was a 9-0 unanimous decision recognizing the so-called ministerial exception, which says that the civil courts cannot get involved in employment disputes between churches and clergy. There's a lot of language in that case that suggests that the reach of the First Amendment guarantee of religious freedom is broad and robust, and that would be another defense you would have. And let me also mention this, which I think is a very strong point, and that is that when you stop to think about it, there are many ministers in this country that refuse to perform marriages for any number of reasons based on their doctrinal positions. And let me mention what some of those are. How about if somebody came to a pastor, Jerry, and said, "I want to marry 2 women"? Well, I'm not going to perform that marriage. It violates my religion. Really? What about being sued? Do ministers ever think about that? Or somebody comes in and says, "I want to marry my mother," or "I want to marry my grandson," or "I want to marry my dog," or "I want to marry my brother or my sister," or "I want to marry my first cousin," which is legally recognized in 21 states, by the way, Or I want to marry somebody who's previously married and divorced. That's legal, but many ministers refuse to perform such a marriage for doctrinal purposes. Or I want to marry someone who's not a member of my faith or of our church's faith. Many pastors, referring often to 2 Corinthians chapter 6, verse 14, a passage of scripture which says, don't be unequally yoked to others. They view it as contrary to their religious beliefs to perform a marriage between a person, maybe a member of your church, and someone who's not a believer, not a Christian. Have they been sued? So there's just a number of reasons, Jerry, why ministers don't perform marriages based on their religious considerations. And in the 237-year history of this country, no minister has been prosecuted or found liable for refusing to perform one of these marriages based on religious views. And I would put same-sex marriage in the same category.
Let me ask you a question there. So if a state recognizes same-sex marriage, do you see it as a possibility that the courts could actually say, if you refuse to do same-sex marriages in these states where it is legal, that you could lose your tax-exempt status?
No, I don't think there's any way I see no, I can't connect those dots.
Okay, it's a good, I thought that was a good question.
Yeah. Anything's possible, but we're dealing with probabilities like in quantum mechanics, and I just can't see that as happening. Now, so just in terms of some conclusions here, same-sex marriages are recognized as legally valid in those 13 states, plus the District of Columbia. Let me mention those states, by the way. We've talked about them a lot. Those would be California, Connecticut, Delaware, Iowa, Maine, Massachusetts, Maryland, Minnesota, New Hampshire, New York, Rhode Island, Vermont, and Washington. I've looked at each one of these state laws. I've just written an article for my Church Law and Tax Report newsletter, the upcoming article, September, October of 2013, and I quote each of these 13 laws, and in some cases they're Supreme Court rulings of that local state Supreme Court. Each of these cases has a recognition of a broad right on the part of clergy to marry whomever they want based on their religious considerations. So I want to make that point very clear.
We do have a question this is a good question that was asked, and it says, what are the implications on educational institutions, both secondary and higher, that receive federal funding who discriminate either on employment or admissions toward individuals of same-sex lifestyles, now that the federal government recognizes this as a viable form of marriage in 13 states?
Well, that's one of the many issues we don't know an answer to that. That will be determined with future litigation. It's hard to speculate as to how. I think you may even see differences in interpretation by different federal courts with regard to an issue like that. But
okay.
There's not a definitive answer to that based on the Supreme Court's DOMA decision, unfortunately.
Okay, well, that's a great question. Unfortunately, I know we're getting we're basically out of time. Is there anything else that you wanted to share?
Well, yeah, I do. I want to share one more issue, which is I get this all the time. Do we need to amend our church bylaws to define marriage as a union between a man and a woman? I'm not opposed to doing so. If you want to do it, go ahead. But my church hasn't done so. And I just want to make some comments here in closing. Like I said, no court in the 237-year history of our country has found a minister liable, civilly or criminally, for refusing to perform a marriage contrary to his or her religious beliefs. Many church bylaws that I've read already are broad enough to embrace strong provisions of scriptural authority that would be enough to I think, give you the flexibility to make that decision on your own without an explicit definition. Another point is the bylaws are not a place to be defining marriage. I mean, if you want to have a policy manual, okay, but bylaws are the rules of governance and administration of your church. And this kind of thing, to me, is just out of place in a church's bylaws. Let's see. So anyway, the bottom line is this. I'll be monitoring this, Jerry, and when I start seeing even the first case attempting to sue a minister or church for refusing to perform a same-sex marriage that is or is not valid under state law, believe me, I'm on top of it. I'll be monitoring. And if there's a need for counsel, if there's a need for warning, I'll be the first person to do it. But I also say this, that I don't know that a provision in your bylaws defining marriage as a union between a male or female would even work. A court could ignore it, and as I said, you can prove your doctrinal position by testimony. You don't have to have a provision in your bylaws necessarily to do that.
You know, we always try to be cutting edge, and we try to, you know, the 2 Supreme Court rulings happened, we answered it. FEMA just came out with some recommendations for churches and how they should respond to emergencies, and that just came out. And I think that's what we're going to try to talk about next time, is FEMA's response and whether or not what our response will be to FEMA based on their decision. So join us next time for Risk Management Live when we talk about the FEMA's responses for churches to respond to emergencies. So we'll see you next time. Thank you.